evening to all. Today we are actually discussing the most important news which are reported in Hindu Daily, the month of May. It is actually, the section is mainly intended for the LJRF OIS editors and LJRF OIS editor trainees. And I think the section will be useful for those law students who are preparing for competitive law examination, especially the UGC and UGC NET examination, and also the municipal magistrate examination and other relevant examinations. So I think I selected some of the important topics which I read. When I gone to the Hindu newspaper, which I consider very relevant in the constitutional point of view. So first of all, I think you are seeing a slide where the Hindu reported two important news. One is a case which is closely related to both are case which are closely related to the religious secular aspect of India. That one incident was happened in Karnataka, and the another incident was happened in. So in Karnataka, what happened was a hijab issue, and in Gujarat, what was happened? The Gujarat government decided to teach Bhagavad Gita in government schools in Gujarat. So, as you know, that Indian Constitution is a secular constitution, and you know the importance of secularism is a basic structure of Indian Constitution. So, in the first incident, the Muslim girls' right to wear hijab is a constitutional right, or which is a part of freedom of religion under Article 25 of the Constitution. So this case was decided by the Karnataka High Court, and the appeal is pending before the Honorable Supreme Court. So wearing the hijab by Muslim girl in educational institution, which is part of freedom of religion, what extent the state can impose reasonable restrictions? So the state can only reasonable restrictions on the ground of public order, morality, health, and other provisions of Part 4 of the Constitution. So this case will be decided. Will be decided by this case is pending before the Supreme Court. I hope the case will be decided by the Supreme Court of India, considering the religious freedom guaranteed under Article 25 of Indian Constitution and the reasonable restrictions as laid down in the same article. So my contention is that the Supreme Court can only decide this particular case on the basis of the parameters laid down in Article 25, Clause 1 of the Constitution, on the specific grounds which are mentioned under which are the grounds mentioned in Article 25 of the Constitution, which only includes the public order, morality, health, and other provisions of Part 3 of the Constitution. So the next issue, actually, the state promoting religious philosophies, a particular religious philosophies in schools, as against the secular constitution and a secular state secular constitution. So when you read this particular news, you will understand the fact that all political parties supported this decision of the government, including the Congress and the AAP. Because I think it is because of political consideration, because constitutionally, so we have to think about whether we have to teach a particular religious philosophy in a school, or whether we have to teach the constitutional morality. Because constitutional, I think we have to teach the constitutional moralities first. It is the most important thing, rather than teaching any religious moralities or religious philosophies in schools. Because I think in a secular India, teaching religious philosophies and religious ideas in public institutions are unconstitutional. So these are the two incidents which were happened this month, and as you know, this created a lot of problems in the state of Karnataka, because it leads to different kinds of violation of rights, and which leads to the 7 teachers suspended as girls were written examination in hijab, and also then refusing to remove hijab, students skip SSLC examination. So these kind of activities, if there is a clear separation in between the state and religion, which is essential, which is fundamentally mentioned in the constitution and also specifically mentioned in so many Supreme Court judgments. Otherwise, these kind of problems will definitely arise, and which leads to different kinds of violation of rights. So that was actually reported by Hindu in these particular news. So see whether what happens when a state is unsecular, because as you know that the fundamental difference between a secular state and unsecular state. So when a state is unsecular, then definitely, as you know, that when a state is unsecular, the state will promote a particular religion. So the state will promote a particular religion. For example, Pakistan is a democratic country, but it is not a secular country, and Sri Lanka is a democratic country, but it is not a secular country because in Pakistan, Islam is the official religion, and in Sri Lanka, the Buddhism is an official religion. But consider Taliban and other, you can take any democratic or undemocratic state, what is actually happening. If the state is not secular, then the divine law will be there in that particular state. Because the official religious law will reflect in the system, and which does not satisfy certain important standards, which has been mentioned in the democratic constitutions like equality, liberty, fraternity, dignity of individual, etc., etc. So this is actually what happened in Taliban, because in Taliban, the unsecular activities leads to different violation of the women, including women's life, liberty, equality, freedom, dignity of individual, and also variety of other violation of different rights like right to education, right to work, right to expression, right to speech, right to move, and also a women's right to self-determination. So this was reported in Hindu Daily, which was very serious thing, because this is nothing but it is actually an unsecular activity of the government, and which leads to the I already mentioned the violation of human rights as well as statutory rights. That is a very important thing. So. So the women demanded they demanded for their rights, and this is still happening. So the most important question is, as you know, that India is a secular country, so we have no official religion. So favoring a particular religion on the part of the state is a very dangerous thing, and it will lead to human rights violation, especially violation of those basic human rights laid down in Article 14, 19, and Article 21 of Indian Constitution. So this is the case in case the state promotes any particular religious affairs in its activities. So another important news reported by Hindu, as you know, that this news was very important news, I think, because this Gauri Lankesh case, and in the Gauri Lankesh case, what happened? It is a very sensitive case because of some constitutional issues, and many people, including Gauri Langesh, was murdered because of their voice against the government. Even after 5 years, the trial is just beginning. We already learned the fact that the justice delayed would amount to justice denied. So, which is also a very important fundamental right laid down in Article 21 of the Constitution. So, what is actually happening in India? A very important news was reported in the newspaper, in the Hindu newspaper. The delay in cases is denying justice in the victim perspective and also in the perspective of accused. So in this case, in the case of Gauri Langesh, in the case of in the case of other important cases, Kalburgi, Govinda Pensare, in these cases, the trial is not yet begun. So it is affecting the rights of victim. In another case reported in the same Hindu, which saying the fact that the 82.4 lakhs cases were pending only in UP. So in the earliest slide, I mentioned the justice delayed would amount to justice denied in the point of view of victim. And in this particular slide, I am explaining in the point of view of the accused. So what is actually happening, because this was a speech delivered by Justice Chandrachud, and this was delivered by the Chandrachud, and these in the Benares Hindu University addressing the law faculties. And 82 lakhs cases were pending only in the state of UP. And almost 4.5 lakhs cases were pending in the High Court of Allahabad. And also these cases were, and these 82 lakh cases, 30% of the criminal cases were filed in the last year, only 1 year. And so if it is these 82% is only the 20% of the total cases which is pending in the courts, which means almost I think almost if it is considered as a 100%, then the crores of cases were pending before the various courts in India. So this is a very alarming situation, and how can you make a solution for that is a very important question. Then see another important case, which is another important news reported in the Hindu is this Pegasus case. As you know that the Pegasus case, it is a very famous case. And I think in LJRF voice, Vismaya Shaji editor written 2 articles, and LJRF editor Anna Mariam also written a very beautiful article. But the Pegasus is a very important issue. Why? Because serious human rights issues were involved, and this case is now pending before the Supreme Court. Because why this case is very important? Because of the human rights violations which are directly connected with the freedom, life, liberty, and dignity of citizens. Because state intervention to the privacy and the liberty of individual without the support of law, is unconstitutional under Article 21 of the Constitution. So this case is also a very important case, and in this case is a very important case, and it is pending before the Supreme Court of India. So I think LJRF editors will concentrate on this issue also. This issue is a very important issue. Another important news reported in the Hindu newspaper is sex workers case, and as you know that many women are engaged in this sex work because of many reasons, and that reasons are because many women are engaged in this sex work because of ignorance, because of human trafficking, because of poverty, because of illiteracy, and social and educational and economic backwardness as a reason for this sex work. So, analyzing these facts, this decision, I think, giving special interim protection to these sex workers for respecting their dignity, life and liberty guaranteed under Article 21 is a welcome decision. So I think you will do more research on this topic because this topic is a very important, very important topic. I think Shivaranjani, I think Shivaranjani is the editor trainee. She will be doing a research work on this topic, right to dignity through the spectrum of life of sex workers in India. So this is also a very important news reported in Hindu, and as you know that this is a very important, another important issue, which was reported by all medias, including Hindu, which is the Sedition Case. So, as you know that this sedition case is a long pending case before the Honorable Supreme Court of India. And the last 5 years, 15,000 cases are registered against Indian citizens. 15,000 cases were registered against Indian citizens. Majority of the cases were registered because of the dissent of the people against their anti people actions of undemocratic actions of the government. So as you know that in sedition as a crime under IPC after independence, Kedarnath judgment is a very relevant judgment, and so it is after 1962, it is a duty of the state while arresting any person under sedition law, they have to fulfill the conditional requirement laid down in the Kedarnath case. That was the position. So, sedition it is a bad law which is came in front of the Supreme Court, and finally the Supreme Court asked a question to the central government, and central government in May 7 said there is no need for repealing the law of sedition, and the Supreme Court asked the same question whether there is any abuse of this law, and the central government found the fact that there is some problem with respect to the sedition law, and in May 9th, they changed their view, and they said in sometimes the sedition law is misused, but there is a provision in law which is mentioned by Tushar Mehta, the Solicitor General, that whenever there is a misuse of sedition law, there the Constitution Code and remedies. So it is actually a very important law which was misused by the government. So the Chief Justice of India, who mentioned the fact that meanwhile those booked will be in jail for months. We cannot ask each and every individuals to go to court. That is the answer for the question of Tushar Mehta, the Solicitor General of India. So, the most important point is the central government said the Kedarnath law is a good law. They use the word good law. They use the word good law. So the most important question is if it is a good law, whether the government followed that good law and applied in these 15,000 arrests, which was happened because of sedition case. So if they did not satisfy Kedarnath decision, which they are saying that a good law, then it is a serious issue, or it is a serious violation of law, or it is a very important human right issue, and the victims are entitled to compensation. So the government realized the fact that there is violation of violation of constitutional provision, and that is one of the major reasons why they changed their mind, and they said they have to they will revisit the provisions of the sedition law. So in that aspect, this particular case was a very important case. And another important matter I would mention, because Dr. Mohan Gopal, the former director of National Judicial Academy, written an article in the Social Science in Perspective, which was published in its volume 14, January-March edition. And it was an article, a beautiful article written by Dr. Mohan Gopal sir, which contains almost 11 pages, where the introductory para of that article is like this. So I will read that paragraph. It is, I think, which is very important. So the nature and contemporary content and scope of sedition and cognitive law must be exposed and explained to the people. Systematic data about the use of this law to suppress democratic activity must be gathered. The illegalities involved in the use of this law must be identified. The sedition law victim must be provided systematic legal assistance to defend themselves. Public awareness must be created on the dangerous essence and impact of these laws. Conference must be organized across the country on this anti-freedom law, demanding their repeal. A national campaign for the repeal of anti-democratic law is required. Public opinion must be created in support of freedom of speech and expression and its significance for the survival and the progress of our republic and for the better future of the people. So this is actually the paragraph, first paragraph of this article, where we can see everything, that is whether there is any violation happen on the part of the state, especially violating the law of the land, which was declared by the Supreme Court, and essentially constitutional under Article 141 of Indian Constitution. And another news reported in the news was also very interesting news, and it was reported in the Hindu newspaper, which is Rajya Sabha debates use of private bill to amend preamble to the constitution. This bill was introduced by a Malayali, KJ Alphonse IAS, and it is a very interesting private bill, where the Alphonse had moved a bill to replace the word socialist with equitable in the preamble of the constitution. So as everybody aware the fact that the socialism is the basic structure of Indian constitution, and which was incorporated in 1976. Before that, 1976 Indian constitution is essentially a socialist constitution. But Indira Gandhi government incorporated an amendment in the preamble, and it included the words socialism, and in number of other judgments in D.K. Nakkare versus Union of India, Minerva Mills versus Union of India, and Excelsior versus Union of India. In many decisions, the Honorable Supreme Court held that socialism is a basic structure of the constitution. So, so actually, it cannot be amended. That is the legal position. But what was happened in the Rajya Sabha, by introducing a bill, an MB saying the fact that this can be amended, and the Biju Janata Dal member also mentioned the fact that the two words socialism and secularism were added to the constitution in the preamble of the constitution by the 42nd amendment, so it can be changed. So I think he didn't have aware of the fact that the law declared by the Supreme Court in the decision I already mentioned is the law of the land. So it is not possible to amend the preamble of the Constitution by way of repealing any provisions of the Constitution, because every provisions contained in the Constitution, including the secularism and socialism, are the basic structure of the Constitution. So this reveals the fact that the parliamentarians need constitutional literacy as early as possible. Another important news which is reported in the Hindu newspaper is, I think, which is also very relevant, which is related to the sports. So, as you know, that the sports activities, the contention came in front of the court is to make sports as a fundamental right. So we can think about this particular aspect because in this particular case, it was a public interest litigation came in front of the Supreme Court, where the contention of the petitioner, one Mr. Kanishka Pandey, he said we have to amend the constitution and sports has to be a fundamental right of the citizen of India. And this case was this case was filed in front of Justice L. Nageshwar Rao. The court also appointed an amicus curiae advocate Gopal Shankar Narayan, and the amicus curiae reported mentioned some important vital point in front of the court, that the establishment of a national physical literacy mission, physical literacy mission, and every academic year at least 90 minutes of every school day will be dedicated to free play and games. And also the report opined that 180 days time should be given to educational institution to publish a physical literacy policy. That is very important thing, a physical literacy policy. And within 180 days, and the report was filed as a public interest litigation plea moved by the person that I already mentioned, Kanishka Pandey, and to amend the constitution to make sports as a fundamental right. Because I think this decision is a very important case, because of the reason that many sporting nations. India is the second largest emerging economy in the world, but at the same time, many sporting nations developed because of sporting literacy and awareness programs, and so many other national missions, especially the missions like National Physical Literacy Mission, etc. Very interesting point is, I think I read an article in LJRF Voice written by Vaishnavi Krishna, a student of Government Law College, Thiruvananthapuram, and that article, the title of the article was is like this: that is the importance of physical education faculties in law colleges in Kerala. So, I am connecting this particular judgment and particular case and that article because of the reason that even in our state we have no physical education teachers in the government law colleges, but at the same time, a physical education teacher, access to a physical education teacher is a statutory right of a law student in Kerala. Access to physical education teacher is a statutory right of each law students in Kerala. So that article was a very fine article, and she did a very good research, and she published that article. I think we can submit that article itself as a research work in front of the government. So the last point, I think, which is also, I think, which is very relevant, which is reported in the newspaper because this case was a Rajiv Gandhi assassination case where Thiruvananthapuram was spent in the Indian jail for 31 years. And he was arrested at the age of 19 by the special investigation team for the assassination, his involvement in the Rajiv Gandhi assassination case. This story reveals the scope of reformation of accused even in very serious crimes. And he got the benefit of delay in execution of death sentence because that delay was continued almost for a period of 15 years. So the question is whether this case is considered can be treated as a precedent for releasing the other prisoners who are in jail in the same circumstances, and also the abolishment of death sentence, which is I think very civilized, which is essential like a civilized country like India. This is also, I think, very important case. I think Dhanush, a student from Government Law College Trivandrum, he will be writing an article on this issue. So these are some of the most important points that I found in the Hindu Daily, which are very relevant in the constitutional perspective and legal perspective. Thank you very much. അങ്ങനെ നോക്കുമ്പോൾ നമുക്കിത് മനസ്സിലാവും. See, 80 Article 80 is what about the Council of composition of the